Good morning. This is the Energy and Carbon Management Commission of the state of Colorado. It is Wednesday, May 7th. It's 9 a.m. and this is our general meeting. Let's start with the roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have five commissioners present.
Great. Good to see everybody. Five is a quorum. Welcome to the folks that are joining us. We're at 78 and counting. Uh, we start with commissioner comments, and I had a comment, and it's really a comment on behalf of all of us, on behalf of all of the Energy and Carbon Management Commission. On May 2nd, last Friday of 2025, the ECMC Class 6 Underground Injection Control Well Primacy application was filed with the EPA. That is a huge undertaking on behalf of our staff and the work that was done. I'd like to individually call out the folks that really were pivotal to getting this done. Michael Rigby, Mark Seeley, Marie Horner, Ben Boudreau, Lauren Mercer-Gelman, Alex Axe, and Kat Campbell. Really want to thank all of those individuals as well as everyone on staff for the phenomenal work on getting that done. It is now with the EPA, and there will be some back and forth as the EPA reviews the application to determine if it is approvable. So, big day for ECMC. Thanks to the folks that worked on that, and we look forward to next steps and to updates. Other commissioners with comments? Commissioner Messner?
Thanks. I've got two comments. One, I wanted to let my fellow commissioners know that over the last 2 weeks, I traveled to both Huerfano County and Los Animas County to meet with the county commissioners there and share the results of the study that was directed by Senate Bill 23-186 to be done on methane seepage study, as well as coal bed methane water quality study in the Raton Basin. Rick Allison was the lead on that and did an incredible job of developing and implementing that study. It's probably the most comprehensive study associated with natural methane seepage and coal bed methane produced water quality that ECMC has done to date in the Raton Basin. That study will be formally out in June, but as part of the requirements associated with SB 23-186, we wanted to let the local governments know the results of those studies prior to publishing that report in June. But huge shout out to both Rick Allison and Chris Sanchez for the work that was done in that study. It's a really interesting study and sets a great baseline for both methane seepage and produced water quality from coal bed methane wells in the basin. And they will be presenting to the commission at a future hearing, but wanted to let folks know that that had happened. And then also wanted to let folks know that on Friday will be a Colorado Produced Water Consortium meeting. There's two upcoming meetings, one this Friday, and then another one June 6th on the Western Slope. One of the primary things that these two meetings will undertake is looking at addressing barriers to centralized produced water storage and treatment. The two meetings, one in May and one in June, are really setting the stage for that discussion. So it's really they will be educational-based meetings. And on Friday, we'll hear from CDPHE around their environmental justice mapping tools. So we'll hear from Rainey Kumar on that topic. We'll also hear from Rick McCurdy, who's the Vice President of Innovation and Sustainability at Select Water Solutions, around technical considerations when building centralized storage and treatment. We'll hear from Kevin Chan, who's a consortium member representing disproportionately impacted communities on engaging communities to identify produced water solutions. We'll also hear from Commissioner Emma Pinter from Adams County and Katie Keefe, who's the Environmental Programs Manager from Adams County, on local government considerations when siting centralized produced water storage and treatment facilities. So that's part of what we'll be discussing in May. In June, we will be an in-person meeting in Garfield County and Rifle. And there we'll have an opportunity to hear from Garfield County and Rio Blanco counties on local government considerations when siting centralized produced water storage and treatment facilities. We'll hear from TEP on technical considerations when building centralized storage and treatment facilities. And then we'll hear from Western Colorado Alliance around engaging communities to identify produced water solutions. And so that will, at that meeting, we'll also have an opportunity to visit a centralized produced water treatment facility on the western slope, and that agenda continues to be built out. But wanted to let folks know that there's two opportunities there to listen into Colorado Produced Water Consortium meetings and provide any comments. All that information is available on the Colorado Produced Water Consortium website. So those are my updates.
Thanks so much, Commissioner Messner. Others with updates? All right, seeing none, we move to consent agenda. Does anyone have questions on consent? Seeing none, I would move approval of consent. Do we have a second?
Second.
Motion and a second. All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Consent agenda carries. All right. Let's now take up two dockets, docket 231-000-313 and 231-100-343. Hearings Manager Thomas, if you could elevate Ms. Jost and Mr. Prashala only at this point in time.
Good morning, Chair Robbins.
Mr. Prashala, I've got the right lawyers, right, for each of the two entities that are seeking OGDP review? Ms.
Yes, you
Jost?
do.
Okay, Mr. Prashala, that's an agreement.
Yes, sir.
All right. I've got some process thoughts, questions before we move into the merits of these OGDPs. And as you all know, we don't talk amongst each other, so this is going to be new for my fellow commissioners to hear from as well. But I do have some concerns about what's on the docket. And to sort of frame this for the rest of the 100 some odd stakeholders, we've got two OGDPs on the docket, both of whom would like to include within their drilling and spacing unit the same minerals. And that is unique to ECMC. We've really not faced this before. So I've got a little statement here. In the parties' joint brief dated October 9th, 2024, the parties agree that, quote, unless one party amends its OGDP to remove Section 2, that's the same minerals, neither the Act nor Commission rules support approval of both OGDPs as currently filed. Joint brief on standards of review, page 1. As to the proposed drilling and spacing units, you both note that, quote, the Commission's approval of the overlapping subsurface development in Section 2 would be counter to the Commission's mandate to prevent or to assist in preventing waste, to avoid the drilling of unnecessary wells, and to protect correlative rights. And that's a statement from your joint brief the two of you filed, page 5. You also note that, pursuant to Rule 307B, the Commission has only three options here: approval, denial, or stay. That's joint brief pages 1 and 2. And you both agree that approval of both OGDPs and the proposed DSUs is not an option. So as I see it, you two are asking this commission to pick a winner. Essentially, you're asking a regulatory agency to resolve your business dispute, in my mind. I don't see anything in the act which authorizes this commission to resolve these conflicting business interests. And in your joint brief, you did not cite to any statutory provision which might grant this commission such authority. You both propose that this commission use Section 116 standards for DSU consideration to pick a winner. But Section 116 does not contemplate this commission choosing between multiple proposed and conflicting DSUs. Section 116 seems to clearly contemplate considering that we consider one DSU application at a time. You both aptly note that the Administrative Procedures Act prohibits the Commission from taking any action which would be, quote, in excess of statutory jurisdiction, authority, purposes, or limitation. Joint Brief, page 2, in which you both cite 24.4.1067B. Based upon that, I'm inclined to conclude that you're asking this commission to take an action outside of our statutory authority. Our rules also don't contemplate this approach. Our rules contemplate us assessing an individual OGDP against our rules, and whether the OGDP is approvable on its own merits, notwithstanding whether there is another OGDP as an option. I wonder, what happens if we determine that both are approvable and protective? What legal authority do we have to pick one over the other? About a year ago, we asked you to sort this matter out and have one of you bring an OGDP for that assessment. You or your clients chose not to do that, and now desire us to take an action which I believe is not in accordance with our rules and outside our statutory authority. I also wonder if we hear both cases and we find both OGDPs to be protective, but we also find that we do not have the ability to pick one to be the winner, whether you two both may run into two denials because of these findings. As one commissioner, I'm inclined to continue both applications indefinitely. Now, without hearing more from the parties on who has the, quote, better application. I know that obviously could have one or both of you sue us under 24.4.1062, which I would discourage. Instead, I'd encourage you to spend your and your client's time determining a resolution so that you can come to us with one approvable application. And Ms. Jost and Mr. Priscilla, this is not an indictment on either of you or your lawyering. You're both excellent lawyers and you serve your clients well. I do believe, though, that this matter is not set in a state for us to hear it now. And I would welcome thoughts from my fellow commissioners as to my thoughts about process and what we should do. Looking around to my fellow commissioners, if you digest what I said. Commissioner Ackerman?
Thank you, Mr. Chair, and I appreciate you bringing this up before hearing the cases in chief. And I couldn't have said it better. I felt exactly the same way. I do think that you laid out exactly as I was thinking. And I would note, as you noted, that we did ask previously in a stay for the parties to work on working this out as it was a business dispute. I didn't really see anything that led me to believe that there was substantial progress made on that front. I would agree that at the least a stay is appropriate at this time.
Commissioner Messner?
Thank you, Mr. Chair. I appreciate your perspective, and I think I would agree with your perspective. The rules that have been promulgated and the act ask us to look at OGDPs specific to whether or not they meet the rules and the act, and not to compare an OGDP with another OGDP and determine that one is better than the other. And so, in looking at these, there, in my mind, is no way that while there may be the ability to meet our rules in the act from a surface impact standpoint, I see no way that these applications, should they both be appropriate from a surface impact standpoint, be able to meet the rules in the act from a subsurface standpoint. And so I think that your approach makes sense to me, and so would support your thoughts.
Other commissioners with thoughts? Commissioner Cross.
Chair, in general agreement with your thoughts. I'm happy to move forward with the applications today.
Commissioner Cross, your mic is causing problems once again,
Is that
unfortunately.
any better?
That's a ton better. Thanks.
I'm in general agreement with your comments. However, I am happy to hear the applications today, happy to have this hearing. I do think that this is generally a business dispute that should be able to get worked out, whether it's trading assets or something else. But I am happy to move forward with the hearing today if that's the way we decide to go. But I do think that it is a little frustrating, at least to me, that nearly a year and a half later, we still haven't been able to resolve this dispute as a business dispute.
Commissioner Oath?
Thanks. I don't know that I have a ton more to add here. I share the concerns and questions about, what authority we have and under what standard we would be reviewing two potentially approvable applications. So I think the path forward that you suggested makes sense to me, and I'd be supportive of that.
All right. Ms. Jost, Mr. Pashala, I think you sort of have now got a feeling on what path we're planning on going forward. Just to avoid you grumbling later, I'll give you a couple of minutes each if you want to say anything. Mr. Pashala?
Yeah, certainly. Chair Robbins, I think Ms. Joseph and I have been kind of conferring off on the side, and as well as trying to confer with our clients at the same time, taking into consideration your remarks. I think at this moment in time, before the commission makes any decision, it would be best if we took perhaps a 5-minute break. Let us each confer with our clients and
let's do that.
And have comments back to you.
Yeah, no, that's fine. Is 5 minutes enough?
Why don't we say 10, if that's fair?
Let's say 10. Let's return at 9:27, and that'll give you 10 minutes to confer with your clients on the musings of the commission. Thank you.
We appreciate
Thank
that.
you, Chair. Chair, if I may.
Yeah, I just saw
okay.
that you need a few more minutes.
Yeah. Could we maybe have until 9:45?
Sure.
Okay, thank you so much, Chair.
Okay. All right, this is the Colorado Energy and Carbon Management Commission. It's Wednesday, May 7th, 9:45. We were giving the parties an opportunity to discuss with their clients this anticipated course of action. I see both lawyers are up, and I see Mr. Pashala, you're unmuted, so perhaps I'm calling on you first.
Sure thing. Thank you, commissioners. We appreciate all of your comments and thoughts on this. We've had an opportunity to confer with our respective clients. There are a couple points that I would like to make before we give your ultimate position. First, I just wanted to address Commissioner Ackerman's comment about no evidence of discussions. These parties have been engaged in numerous conversations, fits and starts with various negotiations to try to resolve this. The reason that you don't see evidence in the record of the discussions themselves is that under Colorado Rule of Evidence 408, settlement discussions are not admissible as evidence. And the reason for that is that if every time there was a dispute, parties were holding up evidence of a failed negotiation or terms that may have been proposed, that can actually have a chilling effect on good faith negotiations. And so that's why you don't see anything in the record regarding any timeline of discussions or substance associated therewith. But I assure you that these parties have been in negotiations trying to resolve this in good faith. Your original comments, commissioners, about trying to get this resolved did not fall on deaf ears. And so I just want to put that out there for you. With respect to your authority on resolving this dispute of competing OGDP applications, we respectfully disagree. We think that under Rule 507 and Rule 510, as well as the Act itself, that the commission does have the authority, statutory authority, and the tools to actually resolve competing OGDPs. Now, that being said, your message is loud and clear. We understand where you're coming from on this. And my client, Verdad Resources, is in a position to accept the commission's offer of a continuance of these matters. And with that, I close my remarks, and I think Ms. Jost may have some remarks as well.
Ms. Jost?
Great. Thank you, Mr. Pearshaw. Thank you, Chair. And, from Kerr McGee's perspective, we agree with Mr. Pearshaw's comments. The parties have been in good faith negotiations for quite some time, actually over 18 months. At this point, I believe that, we were in front of you today because there was not a resolution. We do respect the commissioner's positions on the continuance, and Kerr McGee agrees with that. From the standpoint of the statutory authority, we do believe that this commission can hear competing OGDPs, can hear competing DSUs. There's a lengthy precedent and history of this commission hearing operator to operator challenges. But again, we respect your decision and your position and will accept the continuance. Thank you, Chair.
All right, thank you both. With that, I would move to continue indefinitely dockets 231-000-313 and 231-100-343.
Second.
Motion and a second. Is there further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries. Okay, Ms. Jost and Mr. Pershala, we look forward to seeing you in a different fashion at some point with regard to the applications. And having been stayed indefinitely, you're not having to go back and refile or any of that stuff. So we wish you the best, and we'll see where we come to next.
Thank you, Chair.
Thank you, Chair.
All right, commissioners, with that, the business on the agenda is concluded. Do we have a motion to adjourn?
So moved.
Second.
Motion and second to adjourn. All those in favor signify by saying aye. Aye. Any opposed? Motion carries. We'll see everybody at the next time. Thanks.